Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
If you spend any time online, you've probably had this happen. You click an ad on a website and boom, you're instantly somewhere else.
Right, a totally different digital address. Different logo, different colors.
Yeah, it feels like you've been yanked out of the site you were comfortable on. It's annoying for you, the user.
And for the website owner, it's a real problem. They call it traffic leakage.
Exactly. Well, today we're diving deep into a really landmark case that drew a critical line in the sand about how you could legally solve that problem, especially in the early days of e-commerce.
We're talking DDR Holdings, LLCVHotels.com, LP.
That's the one.
And this is such a crucial case for anyone involved in software or digital innovation.
Why is that?
Because it tackles that huge question that arose after 2014. What kind of software invention is actually, patent eligible anymore?
The shadow of the Alice decision.
Precisely. We're unpacking the Federal Circuit's 2014 decision here to really understand how they drew the line between a patentable technical solution and just, well, an abstract business idea slapped onto a computer.
So the core of this legal fight was around two specific patents, right? The 572 and the 399.
Yes. And they both described a way to stop that traffic leakage we talked about.
Making visitors feel like they never actually left the host site, even when they were buying something from someone else.
Exactly. That was the goal.
Okay, before we get into the tech, let's get the case basics down. Who, where, when?
Right. So this decision came from the United States Court of Appeals for the Federal Circuit. The date decided was December 5, 2014.
Okay.
The official appeal number is 2013-1505. The plaintiff, the one holding the patents, was DDR Holdings, LLC.
And the defendants? Hotels.com was in the name, but who were they appealing against?
The main appellants here were National Leisure Group, Inc., and World Travel Holdings, Inc. The court just referred to them collectively as NLG.
Got it. And the judges?
It was a three-judge panel, Judges Wallach, Mayer, and Chen. Judge Chen actually wrote the main opinion, the one that saved the 399 patent.
And Mayer?
Judge Mayer filed a pretty significant dissent, which we'll definitely get into.
Okay, great. So let's unpack the invention itself. What exactly did DDR claim they invented way back in '98? What was the tech solution?
So both patents, 572 and 399, claim priority back to September 17, 1998. Pretty early days for this stuff.
Yeah.
And they described a system and method for generating what they called a composite web page.
Composite web page, meaning?
Meaning it wasn't just your standard hyperlink sending you off somewhere else.
Yeah.
This system dynamically pulled together two things.
Okay.
First, the visual look and feel of the original host website, its logo, the color scheme, maybe background images, font.
The branding, basically.
Exactly, the branding. And second, it pulled in the actual product content, like inventory descriptions, prices from the third-party merchant, the advertiser.
Okay. So the whole point was seamlessness. Like you click an ad for a cruise on, say, a general travel blog.
Right.
And instead of landing on Royal Caribbean's site, which looks totally different, you land on a page that still looks and feels like the travel blog. But it's actually showing Royal Caribbean's cruise booking information and maybe even their booking engine.
Precisely. Visual continuity. Before this invention, the standard internet protocol for hyperlinks meant clicking equals leaving.
Right. You're just gone. The host site loses that traffic.
Instantly, and maybe forever. DDR claimed their system solved this problem by, well, essentially fooling the visitor.
Fooling them.
Well, giving them the impression, as the patent said, that they're still viewing pages served by the host, even while interacting with the third-party merchant stuff.
Okay. So DDR had these patents and they sued NLG, this travel agency. When did that happen?
The suit was filed back in 2006. The 399 patent actually issued later, in 2010, while the suit was ongoing.
And NLG was accused of using this exact composite page system for their cruise booking.
Yes, that was the allegation. And initially, things looked really good for DDR.
How so?
A jury actually found in their favor, found that NLG did infringe both patents, the 572 and the 399.
Wow, both.
and they found both patents were valid, not anticipated or obvious, and awarded DDR $750,000 in damages.
That's a clean sweep at the trial level?
It was. But of course, NLG wasn't just going to accept that. They appealed.
Makes sense. What were their grounds for appeal? What were the key legal issues they raised?
They raised three main challenges. First, anticipation, basically arguing the invention wasn't new, someone else had already done it. That targeted the 572 patent specifically.
Okay.
Second, and this is the big one we keep mentioning, patent eligibility under Section 101, that Alice problem. This targeted the 399 patent.
The billion-dollar question for software patents.
You got it. And third, they argued indefiniteness, saying the patent language, terms like look and feel, was too vague to be legally enforceable.
All right, let's take those one by one. Let's start with the patent that didn't make it, the 572. Why did NLG say it was anticipated? What was this supposed prior art?
The prior art they pointed to was something called Digital River Secure Sales System, or SSS.
SSS, never heard of it.
Well, crucially, NLG showed evidence that SSS was operational and actually selling products online as early as 1996 or 1997.
So well before DDR's 1998 priority date.
Exactly. And NLG argued SSS did everything the 572 patent claimed. It was the killer prior art.
So what was DDR's counter-argument? How did they try to save the 572 patent from SSS? Did they say SSS wasn't quite the same?
That was their angle. DDR argued that, yeah, maybe SSS looks similar, but it didn't replicate the overall appearance of the host site.
Okay.
Or, they argued, it didn't replicate a sufficient number of those look and feel elements to truly create that seamless impression. They were suggesting SSS was sort of partial, less effective version.
Implying their patent required a much higher degree of visual matching.
That's what they wanted the court to believe. They were arguing for a higher standard of replication than SSS met.
But the Federal Circuit didn't buy it for the 572 patent.
No, they didn't. The CAFC actually reversed the district court's finding on this one. They held the 572 patent was invalid because it was anticipated by SSS.
Ouch. Why? What was the court's reasoning there?
It came down to the specific wording of the patent claims for 572.
The claim language itself.
Right. The court looked closely at the claims and the agreed-upon definitions, the claim construction, and they found that nothing in the claim language actually required an overall match or a specific number or proportion of visual elements to be copied.
So DDR might have intended it to mean a very close match, but they didn't write it that way in the patent.
Exactly. The claim as written only required the system to identify and use key look and feel elements. Things like the logo, maybe the background color, basic fonts, stuff that identify the host.
And SSS was doing that basic level of identification and use?
Yes. The evidence showed, pretty clearly according to the court, that SSS was already mechanically identifying and using those kinds of key identifying elements from the host website back in 96, 97.
So because the 572 patent was drafted broadly enough to cover just using some key elements,
And SSS already did that.
SSS anticipated the claim, making the patent invalid.
Precisely. The court said the record established by clear and convincing evidence that SSS disclosed every limitation of the 572 claim, a tough lesson in claim drafting.
No kidding. If you want protection for a highly detailed match, you need to claim that specifically.
Absolutely.
Okay, so the 572 patent is dead. But now we get to the really fascinating part, the survival of the 399 patent.
Right. This is where the case becomes so important in the post-Alice world.
Remind us again, the Alice decision from the Supreme Court really tightened the screws on software patents, didn't it? Making it much harder to patent software that just automated existing business practices.
Hugely harder. Alice set up this two-step test, often called the Alice-Mayo test. Step 1. Is the claim directed to a patent-ineligible concept, like an abstract idea?
Okay.
If yes, then step 2. Does the claim contain an inventive concept, something significantly more than the abstract idea itself that transforms it into a patent-eligible application of the idea?
So how did NLG argue the 399 patent failed this test? What abstract idea did they say it was directed to?
NLG argued it was basically directed to making two web pages look alike, or, more broadly, the concept of syndicated commerce on the computer.
Syndicated commerce?
Yeah, or they use the analogy we talked about, the traditional business practice of having a store within a store.
Like, a bank branch inside a supermarket, or that travel kiosk inside a warehouse club like BJ's or Costco.
Exactly. NLG's argument was DDR just took that old business idea and applied it using the internet. That's abstract, they said.
That sounds like a classic Alice argument that often wins. Why did the Federal Circuit disagree here? Why wasn't the 399 patent just an abstract idea on a computer.
This is the absolute core of the decision. The court made a critical distinction. They said that 399 claims were not merely about implementing that old store-within-a-store idea online.
Okay, how are they different?
The court found that the claimed solution was, and this is the key phrase, necessarily rooted in computer technology.
Necessarily rooted in computer technology, what does that mean in practical terms?
It means the invention wasn't just using the computer as a tool to do something humans already did. Instead, it was solving a problem that only exists because of the way computers and the internet work.
Ah, a problem created by the technology itself.
Precisely. The problem wasn't just how do we put a store within a store online. The problem was, how do we overcome the inherent, routine, conventional behavior of Internet Hyperlink Protocol?
Which is?
Which is that when you click a link, the browser is designed to instantly take you away from the current page and server, causing that jarring transition and loss of traffic. That's a technical feature, or maybe limitation, of the network itself.
Okay, I see the distinction. It's not automating a business process, it's intervening in a network process.
Exactly. And the 399 claims didn't just state the goal of overcoming that. They supposedly specified how. They described a system.
What did the system do?
Where an outsourced provider computer automatically intercepts the click, identifies the source page you came from, looks up stored visual data associated with that source page, and then dynamically generates that hybrid web page we discussed, merging the host's look and feel with the third-party merchant's content instead of just following the standard hyperlink path.
So it's a specific technical manipulation of the data flow.
Yes. The court saw this specific process, intercepting, identifying, retrieving stored data, generating a hybrid page as something that overrides the normal function of the network protocol.
And that override, that specific technical implementation, was the inventive concept.
That was the significantly more that Alice requires. It wasn't just the abstract idea of keeping the look. It was this specific, unconventional, computer-based method for achieving that result by manipulating the network's behavior. They solved a technical problem inherent to the web structure.
That's a really fine but crucial line they drew.
Absolutely. It provided a pathway for certain types of software patents to survive Alice.
But not everyone on the panel agreed. Judge Mayer dissented, right? What was his take? Why did he think the 399 patent should have been invalidated under Section 101?
Judge Mayer had a very different view. He basically said the majority was wrong, and the claims still didn't pass the Alice test.
Why not?
He argued that the claims disclosed no genuinely new technology or inventive technical concept. He saw the underlying goal, keeping the pages looking similar, to increase sales, maybe by, as he put it, confusing consumers as purely entrepreneurial, a business tactic, not a technical invention.
So he stuck to that store within a store analogy.
Very much so. He insisted it was just translating that old concept to the web. He wasn't convinced that solving an internet-centric problem was enough.
He felt the majority created a loophole.
Essentially, yes. He argued that limiting the use of an abstract idea, like syndicated commerce, to a specific technological environment, the internet, shouldn't magically make it patent eligible if the core concept remained abstract and non-technical.
A fundamental disagreement on what constitutes a technical solution versus a business method using tech.
Exactly. A really stark contrast in viewpoints on the panel.
Okay, before we get to the overall significance, did the court address NLG's other argument that the term look and feel was too indefinite?
Yes, they did. NLG argued that look and feel was subjective and vague, failing the definiteness requirement of Section 112.
But the court upheld it.
They did. The Federal Circuit affirmed the district court's finding that the term was not indefinite.
Why not? Isn't look and feel kind of subjective?
The court reasons that, within the relevant field, web design and development at the time, the term actually had a reasonably well-understood objective meaning.
Meaning what?
Meaning people in the industry understood it referred to concrete, identifiable visual elements. Logos, color palettes, layouts, fonts, background images, graphical elements, headers, and so on.
So it wasn't just a vague vibe. It pointed to specific things you could identify on a page.
Right. The court felt it provided enough objective boundaries for someone skilled in the art to understand the scope of the claim. It didn't require purely subjective judgment.
Okay, makes sense. So pulling it all together, what's the big picture here? What is the real legal significance, the precedential value of the 399 patent surviving Alice in this case?
DDR holdings is foundational in post-Alice patent law for software. It really established a critical distinction, maybe even a safe harbor.
A safe harbor for what kind of software claims?
For claims that are directed towards solving a problem that is inherently technological, a problem that arises specifically from the nature or functioning of computers or networks themselves.
Like fixing a glitch or overcoming a limitation in how the internet works.
Exactly, like manipulating hyperlink protocol, as in this case. It distinguished those kinds of claims from ones that merely automate a pre-existing human activity or business process using generic computer functions.
So it gave software developers a potential roadmap. If your invention fixes a technical problem with the technology, you have a much better shot under Section 101.
That's a good way to put it. DDR provided crucial guidance that if the claimed invention improves the functioning of the computer or network system itself, it's more likely to be seen as patent eligible, not just abstract.
And what happened with the damages award in the end? The original $750,000.
Ah, right. Well, since the 572 patent was invalidated, but the 399 patent survived and was found infringed by NLG.
The original damages number covered both, right?
It did, so the Federal Circuit had to vacate that $750,000 award. They sent the case back down, remanded it to the district court.
For what purpose?
To recalculate the damages and any prejudgment interest based solely on the infringement of the valid 399 patent. The award had to be adjusted to reflect only the surviving patent.
Okay, got it. So if you had to boil this whole case down to one single, most important key takeaway for our listeners, what would it be?
I'd say it's this. The crucial dividing line between an abstract, unpatentable software idea and a patent-eligible invention, according to DDR, is whether the claim offers a specific technical solution to a problem that only exists because of the technology itself, a problem rooted in the limitations, protocols, or structure of computers or the internet.
Fixing the machine, not just using the machine.
That's the essence of it. If you're just automating sales or organizing information in a known way, that's likely abstract. If you're specifying a way to make the network itself operate differently to overcome an inherent network problem, you might just have something patent eligible under the DDR framework.
That's a really clear and powerful takeaway, and it makes you think, doesn't it?
How so?
Well, think about how much of the modern web relies on solving variations of this exact problem. Embedded checkout windows where you never leave the merchant site.
Right. Affiliate marketing networks that need to track traffic seamlessly.
Content delivery networks that blend different sources. All of these things grapple with maintaining visual continuity and controlling traffic flow across different domains.
Absolutely. And the DDR Holdings decision really set the stage legally for how those kinds of integrated digital structures could be potentially protected as inventions, rather than just being dismissed as abstract business arrangements after Alice. It carved out essential space for protecting innovation in the very fabric of e-commerce.
A fascinating deep dive into a case that truly shaped the digital landscape we navigate every day. Thanks for walking us through that complex decision.
My pleasure. It's a critical one to understand.
Absolutely. Well, that's all the time we have for today. Thanks for joining us. We'll see you next time for another deep dive.